We're so excited today to have the director of the Texas Regional United States Patent and Trademark Office and the director of the Rocky Mountain Regional U.S. Patent and Trademark Office. This is something that our students ask a lot about, so we're just super pumped to have y'all. Thank you again for being here.
That's great. Well, thank you, and thank you so much for having us. We really appreciate this. I'm glad that our brainchild and our brainstorming has come to fruition, so thank you so much for hosting us. Actually, UT is my alma mater, and so I am a Longhorn. I went to engineering school down one of these directions.
Don't ask her though.
And so these buildings are so modern and new, and I am really glad that my alumni dollars are going towards updating the campus. So it is fantastic. But as mentioned, I am the regional director for the Texas Regional Office, and by way of background, I received a mechanical engineering degree here. And I worked for 6 years before going to law school. So I worked for Procter & Gamble. I made Sunny D and Hawaiian Punch. And then I went and worked for Dell as well as in their mechanical engineering group. After that, I went to law school at SMU, and I've been practicing law ever since. And then I came to the USPTO to head up their new office that's starting in Dallas. So Molly, would you like to introduce yourself?
Sure. So I'm not a Longhorn. I went to the University of New Mexico, so I am a proud Lobo. I received a chemical engineering degree, and then I worked in the nuclear field. So I turned nuclear waste entombed it in salt mines. I made basically kitty litter pellets out of other nuclear waste, and also glass rods out of the high level stuff. So quite interesting and great chemistry that went along those lines. I had an experience early on with a gentleman who was in my engineering group who I think probably hadn't said 10 words to me in the entire 6 months that we had worked together. And then one day he got a patent. And I asked him what that patent was about. And I watched this guy who literally couldn't say boo turn into like this very articulate, passionate person about the thing that he had invented. And there was a little spark in me that went, I want to do that. I want to help people do that. So I did. So I went to law school. We both have glutton for punishment somewhere in our psyches. And then came out and became a private practice attorney. And then, like Hope, I went in-house working for 3 different Fortune 200 companies as their in-house patent counsel before I took the job at the U.S. Patent and Trademark Office. So I think between the two of us, we've been stakeholders of the agency for almost 40 years. And then we've got a combined 6 years of experience at the U.S. Patent and Trademark Office because Hope is my twin in the office. She started 1 week before I did.
That's right. I have seniority. Okay. So what we're going to do is we're going to talk a little bit about our agency. We're going to give an overview of intellectual property, and then we're going to dive a little bit deeper into provisional patents.
Does anyone here have a patent, by the way?
Has anyone heard of patents?
Yes.
Okay. Okay. All right. Okay. And then how many of you have a trademark? All right. Copyright, trade secret. All right. Okay. Copyright. Okay. So your copyright. What is your copyright on?
So I have a startup that's doing hydroponics
Cool.
automation, and so I'm interested in the provisional patent, and we're using trade secrets to protect all of our software and then copyrights and our marketing assets.
Perfect. All right. Okay, so we are pretty free-flowing, so as long as you have questions, feel free. You don't have to wait till the very end, and feel free to just raise your hand and stop us, and we're happy to answer your questions along the way.
And if perchance we go down a rabbit hole and we don't come back out and your question still isn't answered, remind us and bring us back around. We promise we'll get there.
Okay, so what I wanted to start off with was the tie between intellectual property and the U.S. economy. We know that there is a huge tie between intellectual property and the U.S. economy. The two have a symbiotic relationship. When intellectual property is being generated and it is being utilized and it is being licensed out, we also know that it drives the U.S. economy. And so right now we know as of 2014, there have been almost 28 million jobs that have been created that is related to IP and it accounts for almost 40% of the United States GDP. On average, those who are in the areas that have intellectual property that's associated with business make more money than those who do not practice in those areas or work in those particular industries. In the legal arena and in the intellectual property field, we do know that there have been about $115 billion in revenue, licensing revenue, which is the renting out of intellectual property, as I like to call it, across 28 different industries. So huge industry across the board.
I have no idea why I'm going to be doing the IP in the Texas economy.
Do you want me to do this one?
You can do this one.
Okay, I'll do this one. So intellectual property-wise, Texas is also a huge beneficiary of IP. So Texas, if you did not know, Texans receive the second most number of patents out of any state in the country. So California is number 1, Texas is number 2. Who knows what's number 3?
New York.
Yes, New York. Very good. So New York is number 3. And so there are 5 million jobs in Texas that are associated with intellectual property. And there are almost $22 billion every year spent on R&D associated with intellectual property. UT is a great contributor to that, and it is one of the largest institutions on providing R&D, and actually from an intellectual property standpoint, worldwide ranking, UT is number 4, okay? So huge generator of intellectual property and of R&D and research just right here at University of Texas. Texas is the number 1 exporter of all intellectual property out of any state in the country, so lots of things flowing out of the Port of Houston, the Ship Channel, out of the airports in Houston as well as Dallas, lots and lots of intellectual property that's just flowing throughout the entire economy in Texas.
All right, this one I can do.
Okay.
So the USPTO is a much larger agency than I think people understand. We are a fully user fee funded agency. That means we take no taxpayer appropriations, only user fees. And so we have about 12,500 employees across the 48 contiguous United States and Puerto Rico. About 2/3 of them are on the patent side, about 1/3 on the, actually it's less than 1/3. 2/3 of that 12,500 are actually patent examiners, so they have science or engineering degrees. There's about 500 trademark examining attorneys, about 100 people associated with our trademark trial and appeal board, and they do not have engineering degrees, but most of them have law degrees. So we're a very highly educated workforce in the agency. In patents for FY18, we received a little bit over 640,000 patent applications last fiscal year. That runs from October 1st to September 30th. We issued about 330 patents last year, including patent number 10 million, which is when we started using this cover for the patents. And then on the trademark side, now one of the things that I know for those of you who like to do math in the room, which we already established wasn't me, that's not a 1-to-1 ratio, so don't think that half of all patent applications get rejected and not because you don't get through a patent application in a fiscal year. But on the trademark side of the house, with 468,000 trademark applications filed and only 273 certificates of registration issued, it's a little bit more of a 1-to-1. You can get through a trademark application in anywhere from 6 to 9 months. So that's some of just the stats about us. You want me to do USPTO offices too?
Yes.
All right. So since about 1790, when the U.S. Patent Office traces its history, our first patent, does anyone know who our first patent examiner was? Thomas Jefferson. Yeah, very, very cool. Anyway, since about 1790, we've been located in one location, Washington, D.C., or within viewing distance of Washington, D.C., like our Alexandria campus is now. In 2012, we set, a mere 220 or so years of culture and history on its head. And we opened up our Detroit office. The Elijah J. Midwest Regional Office was opened in July of 2012. In 2014, in June, we opened up the Denver office, which is the office that I run. And in 2015, we opened up Silicon Valley and then our Texas regional office, actually within a month of each other. So, you know, for an agency that hadn't really changed for 220 years, we did it all in 3 years, which is, I think, nothing short of miraculous government work.
So this is a picture actually of my office. So my office is physically located in Dallas, but my office covers 8 different states. And when I'm discussing coverage, I wanted to clarify a little bit. Coverage is from an outreach perspective. So if there are educational opportunities like this one, events like South by Southwest that are happening in my region, then my office is the primary office that's going to be covering those events and supporting and staffing those events. What it doesn't mean is that if you are an inventor or a business owner and you file an application within the USPTO, it's not necessarily going to be reviewed by my office. And so just because you live in Texas doesn't mean that your application is going to be reviewed in my office. Same thing with Molly's office. Just because you live in Denver or you have a business in Denver or in the Colorado area doesn't mean that it's necessarily going to be reviewed by an examiner in those offices.
It sometimes happens.
It sometimes happens, and there's a couple of reasons for that. If you remember, Molly mentioned that we have about 8,100 patent examiners that are spread throughout the entire country. My office has hired 120, okay? And so my office cannot support Texas inventions alone. I mean, there are 10,500 patents that are filed in Austin, in Dallas, and in Houston, each individually per year. And so my office cannot support that amount of volume on a regular basis.
Because we don't want to be creating, we have one backlog as an agency, we don't want to be creating individual pockets of backlogs, so.
Right.
So examination or applications are routed according to the technology that's covered in the claims of the patent. They get routed through something that we call the US Patent Classification System. And so it gets routed to a particular technology center, and then it gets routed down to an art unit, and then it gets routed down to a particular examiner based on experience and workload. So.
Right. And each of our examiners are highly, highly, highly specialized. So for example, you might be an examiner and the only patents that you see are antenna patents. Anything that is related to an antenna, whether it's on your car, whether it's on a radio, whether it's in your phone, that is your specialty area. There's another examiner who may be only looking at lights, illumination, and so that is their art area, as we call it, and so no matter what application that's on, that is their technology specialist. And so because they are so finely specialized, we can't hire everyone in every technical area. And then in the emerging technical areas, there are things that we don't even realize that are being developed. We can't predict the future, although we try. So we need to be able to have the flexibility to staff. So anyways, that is a long answer to that particular question. So,
innovation ecosystem. So I like to simplify this slide a lot, which is I'll talk to anybody about intellectual property at any time of the day, including the grocery store clerk because she's checking me out. Because, and I fully realize what side of normal this puts me on, but I absolutely am very, very passionate about intellectual property. Having been an IP attorney for over 20 years, I've seen it make and break companies and individuals, and I've been inspired all along the way by what intellectual property can do. So from an outreach perspective, right, we do a lot of different conversations about intellectual property at different levels. And one of the things that we do is tailor the message to whichever audience we happen to be talking to. So some of our conversations yesterday, you know, when we were staffing our booth at South by, for some of the entrepreneurs who are well on their intellectual property journey, right, we were having some pretty sophisticated conversations. For other people who are just starting out, we're there to help you with the basics. But the main upshot of all of that innovation ecosystem is that we believe that invention can happen anywhere at any age. And we believe that we are here to help you and support you. So I totally recognize that when someone stands in front of you as a federal government official and says, I'm here to help you. I know how that sounds, but it absolutely is true. We're not that monolithic government agency. We are very hip too, because we're on Facebook.
Instagram.
We are on Instagram and Twitter and YouTube.
Okay, don't ask us if you know how to use it, but.
No, we're lawyers, we don't tweet. Like, the only thing I can say on Twitter is it depends, because that's all I can get out in 300 characters.
Okay, so now I'm gonna move into, and we're gonna probably just like fly through this section, okay, on the different types of intellectual property, because I do want to get to the substance in which we want to focus on, which is provisional patents, okay? So when we think about intellectual property, we think, let's think about the words themselves, intellectual and property, right? What does that break down to? Intellectual is something that you come up with, that you develop in your mind, and it becomes property. It's something that you end up owning. So intellectual property is like real property, right? In which it's like a house, it's like your computer, it is anything, stocks, anything else that you own, you are able to do anything you want with it. You can sell it, you can rent it out, and in IP terms, that means that you are licensing it out, and you can give it to your heirs. You can do anything that you would normally do with any other piece of property, except that it is intellectual property. It is things that you have created in your mind and you have developed yourself.
So there's 4 types of intellectual property. When we refer to intellectual property, it's actually an umbrella of 4 different types of legal rights. And we'll talk a little bit about each one of them. Usually when people start talking about the intellectual property system, though, they kind of devolve down to just talking about patents. We think that's a mistake, especially for people who are interested in starting a business or running a business. You really need to be considering all 4 types of intellectual property because they all have strengths and weaknesses. But there's patents, trademarks, copyrights, and trade secrets.
Okay, so I'm going to give you a quiz, all right? So when you're looking at your mobile phone, all right, one of the things that people don't realize is that there are hundreds of thousands of intellectual property rights that are in here. There are hundreds of thousands of patent rights in and of itself, okay? So with this particular phone, and this phone is not the phone that is up here because this is a Samsung phone, you look at trademarks, right? So it's a source identifier, and we'll go again in a little bit more depth in a little while. So this is a big overview. So Samsung is the name, you know, when you look at that phone and you find the name, you know who is making that particular product, and you know the actual product name, which is Galaxy Note. And those are the 2 trademarks because you know who is making that particular product and that particular phone.
Although depending on how many apps you have on the phone, you might actually have a couple hundred more trademarks associated with that.
You could, yeah, but those are each of the individual apps. But the phone itself is the Galaxy Note and Samsung. Okay, so for patents, Molly.
There's patents associated with the camera. There's probably actually maybe 100 or more associated with the camera, the battery, the screen, antenna, data processing methods, semiconductor circuits. Someone put out a study that said conservatively there's over 30,000 patents that are associated just with the technology that's inside your mobile phone.
Okay, so design patents is another type of patent. It covers the look and feel.
Well, I was going to say, and just to celebrate International Women's Day a little bit more, and Women's History Month, actually one of the things that's in all of your phones, GPS and Bluetooth, the frequency hopping technology was created by, does anybody know? Hedy Lamarr. So she was a famous film actress in the 40s, and as part of the World War II effort, she and her pianist actually developed a frequency hopping system. They donated it to the Navy so that the Navy could use it to not have their signals jammed by jamming technology. So it was a frequency hopper, and that's what forms the basis of your cell phone's GPS and Bluetooth. I might have one of those trading cards here.
So the other thing that's in here is design patents. So design patents protect the look and feel of the actual patent itself. One of the biggest patent infringement cases lately was a design patent, which was the Samsung versus Apple, the cell phone wars. And so huge battles on design patents, and it was over the look and feel of the actual phone itself. Copyright is another bucket that is protected in here when we're talking about software. Software is protected by copyright as well as by patents, but it is an artistic work that is embodied in a tangible medium. All right, we'll go into more definitions a little bit later, but software is included in that as well as instruction manuals and ringtones because they're saved onto a hard drive, so that's the tangible artistic work saved into a tangible medium, which is your hard drive.
And then we're pretty certain that there are trade secrets in the mobile phone, but we don't know what they are because, as the name might imply, you're supposed to keep a trade secret secret.
Okay. Sorry. All right.
You may have mentioned this. Is there room for questions at the end?
Interrupt now.
Oh,
What
okay.
question do you have?
So you mentioned that there are 30,000 patents on a phone in general. Does that
Minimum.
mean that the 30,000 people each get a piece of like every phone that's sold? What exactly does that
Depends
mean?
on what licensing arrangements they were able to commercially obtain,
Okay.
right?
Okay.
So let's take the antennas, for example. So the antennas, there's probably like 4 or 5 different antennas in your phone, and they may be owned by all the same companies or manufactured by all the same companies, or they may not be. And so each of them could potentially have a different license associated with each one of the antennas, and there may be a small royalty that's associated with each one of them. So when you buy your phone, like your Apple iPhone, Apple has some sort of licensing agreement with all the component makers as well as the software providers who have contributed to this particular phone. And in that, incorporated into the price of the $1,000 phone is the license fees that they have to pay out to all the patent holders. Because Apple doesn't hold all the licenses and they don't own all the intellectual property that is included in their phone.
And then, sorry, just one quick follow-up.
Yep.
And so the onus is on the patent holder to actually see if their license is being used.
So we'll skip ahead a little bit, but a patent is a right to exclude others from making, using, selling, offering for sale, or importing into the United States. It is not a right to manufacture. It's not a right to use. It is a right to exclude others. And that's a very important difference because that means you as the patent holder and actually you as the intellectual property owner in any of the 4 legal rights. The onus is on you to enforce, right? So the onus is on you to detect infringement and then do what you need to do about enforcement. We'll talk about that a little bit more, okay?
Okay, so in real broad strokes, here is the actual legal definition of what a trademark is. At the end of the day, what a trademark is a source identifier. So you know that in the picture that we saw, that the word Samsung, Samsung is the maker of that particular device. Same thing on the Galaxy Note. You know that product line is made from Samsung. So with respect to that, you can also do that not only with goods, but also with services. So if you have a dry cleaning service or any other service, a SaaS service, whatever service you are providing, you can also get a trademark for it because it is a source identifier.
So one thing I will tell you is that trademarks can be words, designs, so Nike, Swish, Target, they can be colors. So if I told you that this bracelet, for the ladies in the room, came in a robin's egg blue box, where did it come from?
Tiffany.
Thank you. Right? That's the power of a brand. That's the power of a trademark. You have the instantaneous consumer association with that mark, whether it's a color, whether it's a sound. If I did do, right? NBC, you know that. Because they have built that brand over the course of, or I actually like the Homer Simpson one a little bit better. Right, but it's also packaging, shapes, smells, colors, all of those different kinds of things. As long as the consumer associates that particular aspect with you and your services or goods, it is and can become part of the trademark principal register.
So the example that we see here on smell is there's a flower, so the plumeria. Someone created thread that smells like plumeria. If any of you have ever been to Hawaii, that is the state flower, right? And so that is the smell that they adopted. There's a lot of stores actually at the mall who have trademarked particular smells for their store. So as you're walking around, okay, think about that as you are walking around and you're like, smell this. So, and you know what store it is. I can't tell you which ones are the ones with the trademarks. I can't remember off the top of my head, but I do know that there are particular stores that have trademarked that particular smell.
My favorite is Play-Doh.
Play-Doh, yeah, Play-Doh, you're right. Okay,
Play-Doh
so
has a
Play-Doh-
distinctive odor, and they've trademarked that smell.
Okay, so if you look at, let me see if I can get the pointer.
I know.
Okay, Look
So-
at this.
It may not be desirable, but it's associated with
It
Play-Doh.
is. All right. So one of the things also that I just want to point out is shape, right? Shape is very distinctive. Okay, we all know what this is. Who makes this? Hershey's, right? So we all know, and this is, what is this called? A kiss. Hershey kiss, right? And so, so shapes are also a source identifier. So anything that you think of on your senses that you see, you hear, you smell, you taste, all of that stuff, is associated with a trademark.
Absolutely, as long as it's unique to you and the goods and services that you're offering. All right, so copyright is anything we usually think of copyright in the artistic sense, so books, movies, art, sculpture, those music, right? They are original works of authorship fixed in a tangible medium. When we say fixed in a tangible medium, especially in the electronic world, with software, that means the minute you hit save, it's fixed in a tangible medium, right? So it's when you get done. Okay, we talked about all that.
No,
See?
it's good.
Okay, so books, movies, codes, sculptures, songs, and actually in any one song that you might hear on the radio, there's
It's copyright.
it's been dead a long time. Okay, so, but one of the good things about copyright, right, is that it lasts for the life of the author plus 90 years. Right, so it is, while it is the longest lasting form of intellectual property, although trademarks can last indefinitely for as long as you're still using the goods or services in interstate commerce. With respect to copyrights, it's that nice long protection, but, right, because this is the government, right, when we give you the right to exclude others from something for a really nice long time, that's a really narrow right? So copyright is, it protects that original work of authorship, and then, but not much more. There's not a lot of room to expand. It doesn't protect how the thing works. So, right, especially with respect to software code, if your software completes functions A, B, C, and D, copyright's not going to cover every ability of someone else to complete those functions using different code. It's only going to protect the code that you have copyrighted that completes those functions. So, right, if you want to do the functionality and protect the functionality of something, you're going to be in the patent world, especially in the software space.
So, okay, so just the only thing that I want to touch on also, so copyright is protecting the exact thing that is created, right?
The
And
expression
so-
of the idea.
Right, so if you have code and someone looks at that code and they write out exactly that code, right, and that is the essence or the artistic form, or it's considered the essence of that code, if they copy that exact code, right, that is what is protected. Now, there are some expansions in which there could be a couple of variations that are associated with that, but that is really the essence of it.
But if if you wrote it in C++ and somebody else writes the thing that accomplishes the same function in Java, that's two different copyrights.
Right. Okay. All right, so trade secret. So trade secret is exactly what the words are, right? It is a secret, something that you want to keep secret, but there is some sort of monetary value that is associated with a trade secret. And so, when we look at trade secrets, it's actually considered the opposite of what you would think of on patents. Okay, so patent is something that you are disclosing to the public.
Although they can still exist in the same product.
They can. So, let me finish distinguishing the
Yeah.
two first. Okay, so a patent, you disclose to the public and you are given, in exchange for that, a monopoly for that particular right, okay? A trade secret, on the other hand, is you keep it secret, all right? And you are not disclosing that to the public. But you have to do certain things to make sure that you protect it, to keep a secret so that you can continue to keep that value up. But they are two opposite ends of the spectrum. They both have a lot of value in the business context, so it's really just a business decision on what you want to do. One of the biggest distinctions on a patent and a trademark on the decision on when you want to use either one is it easy to reverse engineer or discover your trade secret? If the answer is yes, then you're going to probably want to patent it instead of keeping it as a trade secret. Because if someone figures it out on their own and they don't go into your business and look it up or find it secretly from the inventor or the creator of that particular trade secret, then they've done nothing wrong. You sold it publicly, they bought it legitimately, and they reverse engineered and they figured out how that actual thing works. Then your trade secret is lost. So then you might want to consider filing a patent for it.
But with trade secret, you really have to know kind of what you intend to keep as the trade secret. So, right, you don't want to be the manufacturer who says, I'm going to keep my manufacturing process secret and then gives public tours of their manufacturing.
How is the scope of a trade secret defined?
It's defined by the owner, and so really you don't know, like there's no government agency that's going to help you define what a trade secret is on behalf of your business. That's something that you will have to do.
How would
so-
the government agree that that scope has been defined? What would you have to show the
Through
government?
litigation.
Well, the government is not really determining the scope. Usually a lot of these agreements are going to be on paper, as we call it. And so it's going to be the parties determining what the scope of that is, right? So really what you're looking at when you're looking at the trade secret is how big, how much of this, if it got out into your competitor's hands, they were able to take it and make money off of it. Is it only 10% of that, right? If they got 10% of that, and that's the true essence of if someone else found out 10% of this, then that's probably your trade secret, right? But if it's larger than that, then that's how you determine the fence line of what your trade secret really is. At what point, the question is, at what point is it that the monetary value arises for it? So let's take the Coca-Cola formula, for example, okay? So everyone sits there and says, the Coca-Cola formula is not a secret. You can look at the back of a Coca-Cola can and it lists all the ingredients there. Right, I agree that that itself is not a secret. But what is a secret is how much sugar do they put it in? When do they put in the carbonation to be able to put the bubbles to enhance the flavor? That entire process and then the quantity, that is not known. We don't know what that is. And so that is the secret itself. It's not the ingredients, right? It is the recipe itself as well as the process for making the Coca-Cola formula.
And Coca-Cola goes to great lengths to protect that trade secret. There are two scientists, at least according to folklore, right? Two scientists that know each half of the Coca-Cola formula. Neither one of them are allowed to travel together. They're not allowed to live in the same town together, right? And so that's the thing though. You as a business owner and your employees, quite frankly, are your own worst enemies when you have trade secrets. So, and I know in today's collaborative space, right, you know, you don't want to be excluding others and I don't want to say to you, for example, no, you don't get to know that. But if you are going to defend your revenue, if you're going to defend your product, and if you're going to grow your business on the back of trade secrets, you need to be willing to have those hard conversations. You need to have employee badging, you need to restrict access, you may even need to partition servers and those kinds of things so that only employees with the need to know the code actually have access to the code. So, right, it really is a decision that you need to make from the get-go, and you need to know what it is that makes you unique. And then if the trade secret happens to walk out the door, you're going to be enforcing a trade secret action. Now, in the past, that was a really bad conversation because it was a state court action. after the 2016 Defend Trade Secrets Act. That's actually a federal state court, or federal action. And so it makes it a little bit easier, right? Because if it's a state court action, 50 different definitions of what a trade secret is with nuances, 50 different, definitions of what it means to steal a trade secret. With the federal court action, it's one definition across all 50 United States.
I think you may have just answered my question. So if somebody, for instance, had taken the exact ingredients of Coca-Cola, but added 4 cups of sugar rather than whatever their trade secret is that an infringement on Coca-Cola's trade secret? Or
No, I mean, you
Probably
figured it
not.
out yourself,
Okay.
right? It's like reverse engineering, right? You figured it out all on yourself. The only time an infringement, it's actually called misappropriation in trade secrets, but the only time that would happen is if you saw the piece of paper that the recipe and the ingredients was written on, and you either mentally photocopied it, or you actually photocopied it, took a picture of it with your phone, and you walked out the door and you started making Coca-Cola products with it, that's when you have misappropriated their trade secret.
Part and parcel of proving a trade secret action is showing that the person who misappropriated the trade secret had access and did some copy. Right? So,
I have a quick question going back to copyrights.
okay.
Have people, or can you copyright synthetic or non-natural DNA sequences?
Good question.
I don't know if anyone has ever copyrighted it, but let's say you've created a synthetic, a new DNA strand, and you've saved it onto a hard drive, okay? And someone comes along, takes a flash drive and puts it in, or they took a picture of it, let's say, then that is taking that particular copyright.
But is that an original work of authorship?
It doesn't exist anywhere else.
But when
No, it exists.
but it is
Well,
a derivative
I mean,
work.
maybe on the,
Wait,
the synthetic part might be a derivative work.
Right.
But the actual sequence, right, I'm assuming you find in nature.
Not necessarily.
Not
Not
necessarily.
if it's synthetic.
Maybe. Interesting question. We'll find the answer out. If you have a card, let me know. We'll find the answer out. I don't know the answer off the top of my head, though. But my question is it original? And as a work of authorship?
But if you make it synthetic, or is it artistic?
I don't know.
Okay, anyways, great question. Okay, any other questions? Oh, I forgot Krispy Kreme, I'm sorry, there's a fourth one.
Right, the Google algorithm is a trade secret, and Krispy Kreme's recipe for the crack that they add to their donuts is a trade secret, I guess, you know.
Okay,
Those
so
things are cool.
we're happy to give this presentation to you guys. I know
Oh, yeah.
this is extremely hard to read, and these are the 4 different types of intellectual property. Each type of intellectual property has a different time duration on how long they are good. So this actually is a great chart to kind of go through that, but I don't want to spend a lot of time on this because, well, A, it's hard to read.
But
and-
one thing, because there are 5 columns, and we just said there are 4 types of intellectual property. So,
because there are 2 patents, yeah.
so in the patent world, there are actually 3 kinds of patents. Plant patents.
And we're going to go into that in a
Oh,
second.
good, okay. Then let's do that. But plant patents, design patents, and utility patents.
Okay. Well,
We covered this already,
Okay.
sort of.
All right, so it's a negative right, and it excludes people from making, using, offering to sell, and to sell or importing inventions in the United States. So very important jurisdiction is our office only grants you rights in the United States, all right? If you want to go international or around the world, you have to file with their particular patent and trademark offices to get your rights in that particular country.
So all intellectual property rights are global, right? You can get them in any country in the world, with the exception, I think, of trade secrets in some places. I don't think you can keep trade secrets. I think there are some countries that say you can't. But they are territorial, right? So if you have somebody who's infringing you in Canada, but you only have a US patent, not going to be able to enforce that US patent in Canada, right? There's no recognition of those jurisdictions. So, if you have somebody infringing you in Yemen, then you need a Yemenese patent or a Yemenese trademark. So they're global, you can get them anywhere. Query whether you'd want to do that. I see the skeptic in the back of the room, right? But So you can get them in any country in the world, but you absolutely have to have the right in that country in order to enforce.
But if someone makes something overseas and ships it and tries to sell it in the United States, then you could enforce it in the
Right.
United States, right?
So if a patent's just a negative right, what conveys ownership of the intellectual property?
The patent that you get from the U.S. Patent and Trademark
It's a
Office.
negative right. It's the right to exclude others, right?
Mhm.
Is that
Right,
the
and
same-
so,
should-
but
should
the
be
right is
ownership?
actually existing in a piece of paper. When you get your patent, you will get something that looks like this,
Mhm.
all right? And that conveys you your property right. So when you're gonna convey this property right, I'm gonna give this to
It's
Molly.
not a single sheet of paper either. though.
It's not,
Right.
it's like a book,
It's
all
almost
right?
like a book. It has drawings, it has a specification, and at the end of the patent, it has a series of numbered paragraphs that are written in nothing that looks like English. But they're a series of numbered paragraphs, and they are written as if they are the legal deed to what you have invented.
And there's a number, right? So you're conveying that number, I'm conveying the number of this patent to Molly, right? And, or I am licensing it out to her. That is what you're conveying over to her, okay? All right, so as Molly was saying, and jumped the gun, there are 3 different types of patents. All right, so the utility patent is probably the one that you think of the most, and that is the one that describes the functionality of a particular patent, all right? And so if you invent new material for a particular thing, or let me take a tennis shoe for example. A tennis shoe is a really good example, right? So you can take the tennis shoe, if you create a new material that whisks away your sweat, all right, that is something that you can patent. If you actually create the machine that is going to make the actual tennis shoe, that is something else that you can go ahead and patent. If you create a whole process line of which you are going to put on the sole, then you're going to add the shoelaces, and then you're going to add other parts of the tennis shoe, and you're going to sew it all together. That entire process is also patentable within a utility patent. So there has to be some sort of functionality associated with a utility patent. So,
And then next come design patents. So using the tennis shoe, right? If you've got, a tennis shoe that has a new shape, and the shape isn't part of how the tennis shoe functions, but it's ornamental, it's a design choice. You can actually get a design patent, and a design patent protects the way that something looks from an ornamental perspective. I have a design patent supervisory patent examiner in my office, because when I think ornamental, I think pretty, right? He's like, no, they're ugly. You can get a design patent on something that's really ugly, because that's still a design choice. And then he proved it to me by showing me patents that he himself had issued. So I was like, cool. But actually, the people who hold the most design patents is actually the automotive industry. And it's focused also on the grills of the cars. And so, right, because those are ornamental design shapes that the car companies like to have be unique. One of the interesting things, too, is the relationship between design patents and trademarks. So remember how we talked about trademarks for source identifiers? There have been multiple companies who have started out with things and their shape is design patents, and then they've turned them into 3D registered trademarks because that shape has become so associated. Does anybody in here have a dog? Anyway, do you use Kong for the dog products?
I have.
Yeah, so you know the shape balls? Okay, so I worked for that company when I was in private practice, and I helped him get a 3D registered trademark on that shape.
With a goofy little ball that.
Yeah, for the goofy little balls.
so,
It's awesome.
so for the non-dog owners,
The Coca-Cola bottle
yeah,
is a good example.
the Coca-Cola bottle is an example, right? I mean,
Started
it
out as a
is-
design patent.
Yep, and then now it is associated with the Coca-Cola product, and so now it is also a 3D trademark.
Right.
Okay, the very last type of patent is a plant patent, and so a plant patent is anything that there is some sort of human intervention that is associated with it. So you can't go outside and pick a bluebonnet and go into our office and try to get a patent on it. You have to do something to that and change the bluebonnet so that maybe it's no longer a blue color and it is now a pink color or an orange color or any other color. And once you do that and you alter it somehow, you can also get a plant patent associated with
It
that.
must be asexually reproducing now.
Yes. Okay. Oh, yes, I could have used that. All right, Molly?
Okay, so the path to a patent, you come up with an idea, you noodle on it, you figure that out. A lot of people, especially as they're starting out in bootstrapping, will use something called a provisional application. Just so you know, there are no provisional applications for design patents, so it's only in the utility patent space that people are talking about provisional applications. And a provisional application, you can think of it as a placeholder. It gives you a serial number and an early filing date. And so it's really useful for people who are starting out. It's also really useful since the law changed in 2000. Well, the statute came into effect in 2011. It really changed in 2013. But the United States is a first to file patent system, meaning that he or she who wins the race to the patent office is the presumptive owner of that invention. So it matters a lot more now than it used to in patent history and as to when you get to the patent office. So provisional applications are really fantastic for that. Once you file a provisional application, you have exactly 365 days, 1 year, to convert that to a non-provisional application. Provisional applications are also kept confidential by the U.S. Patent and Trademark Office. No one sees them, no one examines them. Nothing is looked at until you convert to a non-provisional application. Once you convert to a non-provisional application, it gets assigned to an examiner like we talked about. The examiner will go through the process. They will examine the patent application according to the statutory criteria, which is utility, usefulness, patent novelty, non-obviousness, and whether or not the patent is, the description is clearly articulated. So they will issue you a rejection. Again, not an excuse to find the tallest building that has windows that open. It is actually an invitation to have a conversation with the examiner, to explain to them how your invention is unique over what they've cited to you. So have the conversation.
So I'm going to go a little bit more detail into the provisional patent application. So
And there's a question in the back.
Oh, yes,
And
sorry.
if you have a provisional, right, and it's secret,
Yep.
and then somebody else comes in with sort of going up to the full patent level, tries to leapfrog you, what happens? You just sit on the other second application until you deal with provisional? What
Well,
happens there?
No.
So, okay.
Short answer is no on that one.
Yeah, so what happens is that, well, the good thing is, in order for you to secure your rights, you have to convert your provisional application to a non-provisional application. You can never get a patent on a provisional application, okay?
There's no enforceable right in a provision.
Okay, so there has to be some sort of conversion. So you have that 1 year time frame. Now, okay, good or bad, it takes us longer than 12 months to actually review a patent application. So on average, we have about 24 months. So by the time that other patent application, that non-provisional patent application is reviewed, that's filed after your provisional application, your patent, your provisional should have been converted to a non-provisional application, right? And because you filed first, you get rights to it first. Okay, so even because you filed first before the other person did, and by the time the patent examiner is actually reviewing it, should be able to see it because it is no longer secret anymore because you've now converted it into a non-provisional patent
If
application.
you don't convert to a non-provisional application.
Okay.
Yep.
Okay, so a couple of differences, all right? So as we mentioned on the provisional versus non-provisional application, you must convert to a non-provisional patent application to secure patent rights. When you file a provisional application, you can get the patent pending status, all right? So there is a lot of benefit in getting a provisional patent application, but you only have a 1 year time frame to be able to convert to that non-provisional application, and it's limited on the types of patents that you can do it on. You can do it on a utility application as well as a plant application, and as Molly said, you cannot do it on a design patent, okay? The provisional patent application is never published until it is actually converted into a non-provisional application. There are people that I know that file provisional after provisional after provisional, and they haven't converted it to a non-provisional yet. And so during that entire time period, when they haven't converted to a non-provisional, then they understand, if you file successive provisional applications, your date keeps changing by a year on when your rights are secured, okay? And so that's just something to keep in mind when you're doing that. But one of the big benefits of filing a provisional application, especially for entrepreneurs, is we know that the patenting process is very expensive, and it's hard to invest a lot of money into something you know that's whether it's going to take off or not take off, right? So a lot of venture capitalists and a lot of angel funds, a lot of those organizations want you to have intellectual property rights before they will invest in your company. So you can start getting your funding or advertising that you do have intellectual property rights because you have patent pending, and the provisional patent application allows you to start that process and start to secure the rights.
It also makes sure that you have that placeholder because, right, if you sell or if you disclose your own invention before you file for a patent application, number one, you destroy your foreign filing rights. In the United States, we have a 1-year grace period where you have that ability to not file. But if you disclose or sell before you file your provisional application or end a patent application, you destroy your foreign filing rights. So, right, it's that tension, and you know, one of the things that we hear most often is that venture caps and professional investors are refusing to sign non-disclosure agreements. So if you're disclosing without a non-disclosure agreement, that's affecting your ability to file patent rights and secure patent rights, not just in the United States, but around the world. So the provisional patent application is a really good thing to have on file before you start, like, you know, before you're on Indiegogo or Kickstarter or whatever, you know, other funding mechanism you're going to use for the people who will not sign a non-disclosure agreement. Because if you disclose in public, that starts your clock ticking.
The other thing is that we want to emphasize, and I want to introduce you actually to Alyssa McCain right here, okay? So Alyssa McCain is actually the director for our pro bono program for the state of Texas. So that program is called the Texas Accountants and Lawyers for the Arts. So if you fall below a certain income threshold, then you can seek help from TALA, the organization that she has, and this is the flyer that we actually passed out for you. But the thing is, to get help, at least from patent help standpoint, you have to have a provisional patent application on file. And then their pro bono attorneys can help you convert it to a non-provisional patent application, okay?
One of the other things that I think we should mention is before you invest your money in a patent application, we really recommend that you do a prior research. It's not necessary, but if you're going to be investing tens of thousands of dollars, your time, your passion, your energy into something, I think it's always better to invest that in something you know you can pursue. And so we have our PTRC librarian right here. Look for Lorraine. Thank you. We just met 2 minutes ago, so I'm very sorry about that. But anyway, our patent and trademark resource centers around the country have access to the same databases that our examiners use for searching prior art. And so one of the things that I'll tell you, I mean, Google Natural Patents is a great way to start, but it's natural language. So, right, to you, one of the screws that's holding up that thing is a screw, and that might be what you search on Google. To me, that's a removable fastener. And so you might not be finding the art that a patent attorney has written because you're not using the language that we do. If you're searching in the examiner databases and you do it with our patent and trademark resource centers, you know, they know how to search the way that we patent lawyers make difficult. So,
And the library that Lorraine is at
Yes.
is in the engineering library.
Right
So
here,
it is
right?
right here on campus. And so for those of you who are students here, it's easily accessible, just right across campus, and it's a great resource for you.
and free.
And free. Yes, I forgot to mention it's free. So, okay.
You can also come into the Texas Regional Office or any of the other regional offices and do that same kind of search from a prior art perspective. You can also do trademark searching with the Patent and Trademark Resource Centers, and you can also do that within the regional offices as well.
Okay. So I know we're running short on time, and I know we only have 5 minutes left. Let me go through the provisional patent application requirements. It is, the provisional patent application is not as long as the non-provisional patent application. there's a misnomer, it's called a mini patent, as some people called it, but it's only a mini in the sense of the amount of information or the type of information that you need to provide in order to get it filed. Remember, you do not get any patent rights associated with a provisional patent application until you convert it to a non-provisional, okay? You've got to convert it to a non-provisional. So with that in mind, a provisional patent application, there's actually only 4 things that you need to actually file. You need to file a cover sheet, and there's blanks on the cover sheet that you actually just need to fill out. You need to file a description, which is what we call a specification of your particular invention. You can file a drawing. That's actually not mandatory. You can if you want to, but as everyone knows, a picture is worth 1,000 words, okay? And so it is very helpful usually to file a drawing, and then you have to pay us. I'm sorry, you do have to pay us, and so you need to submit your filing fee when you're actually submitting a provisional patent application.
So when you speak of specifications, going back to the Coca-Cola example, how specific does it need to be? So do you need to have the list of ingredients, or can you say, I'm not sure if I'm going to use sugar, so I'll say I'll put sweetener instead of, I don't know, color brown number 4.
Right, so you need to throw in the kitchen sink, as I call it, okay?
Yeah.
So the key with the provisional patent application is that when you convert it to a non-provisional application, everything that you've disclosed has to be in the provisional application. You can't put in anything new. So when you file your provisional patent application, be as complete as possible, all right? And like I said, every alternative, if you want brown sugar number 14, and you might also want white sugar, then
Or
stevia, okay? You
Like-
want to include all of
So
that
you would say,
in there.
you know, my formula would use sweeteners such as, and perhaps have a laundry list of things, right? You still have to disclose the best way to make it. So you might say, you know, you have this laundry list of things, and then you would say, but the preferred way, the second preferred way, right? Like, there's a whole bunch of things you can do about that. I always like to think of your provisional application as the platform off of which all of your non-provisionals are going to spring off of. So everything that you think you might want to claim down the road needs to be in that provisional application. It's better to over-disclose in the provisional than not.
So let's talk about format of information, okay? So as opposed to a patent, it is, the non-provisional patent application is very specific. There's paragraph numbers. You have to name components on a drawing and refer to them as a very specific way in your specification. And there's an abstract, you know, so
There's
there's
specific things that you have to do in your drawings too.
right, so there's very specific things. There is none of that requirement with a patent, a provisional patent application. So when I was in-house for Xerox and BlackBerry, I didn't file patents for BlackBerry, but when I was in-house with Xerox, often what would happen is, this is the classic of what happens. Hey Hope, I need to file a patent application for a new product that we're going to be launching. And then I'm like, okay, great, that sounds very exciting.
When
What
are
is
you
your-
launching?
Yeah, when you're launching? Tomorrow. Okay, and you know, we work miracles, but we cannot put together a patent.
A
within-
full-blown.
Yeah, a full-blown one in less than a day. So what ends up happening is I ask them for every piece of marketing material that describes what they're going to be launching tomorrow, whatever presentations that they have, and I just bundle that up. I stick it together, slap a cover sheet, pay by fees, and then put some drawings in there, and yes, all of that stuff, and then I submitted it. Because that is all I got, and that is all the time I have within 3 hours or whatever, or half a day that I have to be able to submit a provisional patent application. Not ideal. If you go to a big company, please do not
Don't ever do that to the attorneys at the company.
It's horrible. It is horrible, because that is your fire drill for the day. And so, anyways, so really at the end of the day, you don't need to, it doesn't have to be very formal. The more formal that you make it, the easier it is at the end of the day to convert it. Okay, so when you're thinking about attorney fees and how much time the attorney has to spend, the last thing you want to do is for the attorney to be spending a lot of time deciphering all the piece of paper that you threw in there, right? And so the better you can organize